The Epstein scandal refuses to go away. And the reason it refuses to go away is not because people are obsessed with conspiracy theories. It is because every time a new document drops, every time a new hearing happens, every time a new official sits down in front of Congress and gets asked a direct question, the answers do not close the case. They open new ones. And what just happened in a Senate hearing did exactly that. Because Senator John Kennedy sat across from Attorney General Pam Bondi and asked her something that should have had a straightforward answer, and what he got instead was something that made the entire room uncomfortable. Let me start with Howard Lutnik, because this is where the hearing began, and this is where things got strange fast. Lutnik is the Commerce Secretary. He and Epstein were neighbors for years. Their townhouses shared a wall. And in a New York Post interview, Lutnik described Epstein in a way that nobody in his position had described him before. He called him the greatest blackmailer who ever lived. That was the phrase, the greatest blackmailer who ever lived. And then the reporter pushed further and asked whether powerful men who were around Epstein saw what was happening and looked the other way. According to the reporting on that interview, Lutnik's response was not that they looked away. He said they participated. And then he went further and described how Epstein allegedly operated, inviting people for massages. What happened in those rooms, Lutnik suggested, may have been secretly recorded, and if those recordings existed, they could have been used against the people in them. Now, to be clear, these are allegations. They have not been proven in court. Lutnik has not been charged with anything, but the significance of a sitting cabinet member making these statements about a man at the center of one of the most consequential sex trafficking cases in American history is not something you can just file away. If a senior government official is publicly describing Epstein as a blackmail operation and describing participation rather than ignorance among powerful men, the logical next question is, did the Justice Department talk to him about this? Kennedy asked Bondi exactly that. Did the DOJ interview Lutnik about these claims? Bondi said no. Kennedy pushed, does the DOJ plan to interview him? And here is where the answer got complicated. Bondi said something to the effect that the FBI could talk to him if they wanted to, or if he came forward, which on the surface sounds procedurally reasonable, except it is not how aggressive federal investigations work. When a senior government official publicly describes Epstein as a blackmail operation and says powerful men participated, investigators do not wait for that person to voluntarily come forward. They pick up the phone, they schedule a meeting, they follow the lead. And Kennedy made exactly this point, because the broader question he was asking was not really about Lutnik specifically. It was about whether the Department of Justice was actually following every available lead on the Epstein network aggressively, or whether it was doing something else, something that looked more like managed transparency than real investigation. And then Kennedy shifted gears. And what came next was one of the more startling exchanges in recent Senate history, because he laid out a hypothetical. Suppose a special counsel wanted the phone records of a sitting United States senator. What would they need to show? Bondi explained the legal standard: probable cause, a reasonable belief that a crime had been committed or was being committed, standard legal procedure. But Kennedy was not asking about legal definitions. He was pointing at something specific. Because according to reports he was referencing, during an investigation, multiple sitting United States senators had their phone records subpoenaed. And Kennedy's point was this: that is an extraordinary step. Getting those records requires serious justification and serious oversight. And if a telecom company received a subpoena for a sitting senator's records, that senator should have been notified. Their lawyers should have had the opportunity to challenge it. The phone company's general counsel should have been advising their CEO to file a motion to quash. Kennedy put it directly: this is as serious as a four-way heart attack and a stroke. These are sitting United States senators. And the implication underneath all of it was clear. If the Justice Department had the power and the willingness to subpoena sitting senators' phone records in one context, why did that same aggressive posture not apply to following leads in the Epstein network? Bondi's response was careful. She said she could not discuss the specifics of ongoing investigations. She said she had only recently learned about some of these details. She said Director Patel had also only recently learned about them, and then she suggested that perhaps former Attorney General Garland should be called before the committee, that perhaps former FBI Director Wray should answer for decisions made during his tenure, which is a move that Kennedy recognized immediately, because redirecting toward predecessors is not an answer, it is a delay, and Kennedy said as much. But here is what makes this moment more significant than just another tense Senate exchange. Because this hearing did not happen in isolation. It happened against the backdrop of everything that has already fallen apart in the Epstein file release process. The February 2025 release that turned out to contain mostly documents already available to the public. The client list Bondi said was sitting on her desk that the DOJ's own July memo said did not exist. The reported falling out between Bondi and Patel, so severe that resignation was reportedly discussed. The watchdog complaint finding that Bondi, Patel, and Deputy AG Blanche's own communications were almost entirely absent from over 2 million pages of released documents, and Massey threatening Bondi with inherent contempt for not complying with the Epstein Files Transparency Act. All of that is the context in which Kennedy sat down and asked whether the DOJ had spoken to a cabinet secretary who publicly called Epstein the greatest blackmailer who ever lived. And the answer was no. The pattern here is not subtle. 3 administrations have touched this case. 3 sets of officials have made promises about transparency. 3 rounds of document releases have produced more frustration than answers. And at every point where an aggressive move could have been made, where a lead could have been followed hard, where a powerful person with direct knowledge could have been pressed for information, something else happened instead. A procedural limitation was cited, a predecessor was blamed, an ongoing investigation was invoked as a reason not to discuss details, or in this case, an answer was given suggesting that if someone wanted to come forward, the door was open. The victims in this case have been waiting for accountability for decades. The names in the FD 302 reports, at least 20 of them, have never been publicly released by law enforcement. Not one of the men identified by victims as clients of Epstein's trafficking operation has been charged. And yet, when a sitting cabinet secretary publicly describes Epstein as a blackmail operation with secret recordings, the response from the Justice Department is essentially, "We have not talked to him, but he can come to us if he wants." That is not what an aggressive federal investigation looks like. That is what managed distance looks like. And the difference between those two things is the difference between a justice system that follows the evidence wherever it leads and a justice system that follows the evidence only as far as it is comfortable going. Kennedy understood that. The room understood that. And the frustration in that exchange was not partisan. It was the frustration of watching the same pattern repeat itself one more time. New officials, same result. More promises, fewer answers. And the files, the real files, the ones that would actually tell you who Epstein was working with and what he had on them, still sitting somewhere between sealed and redacted and officially reviewed and found to contain nothing of significance.
If you want to understand why this case will not close, this hearing is a good place to start, because it shows you exactly how the mechanism works, not through dramatic cover-ups or obvious obstruction, but through 1,000 small procedural retreats, through the careful use of legal language, through the redirection toward predecessors, through the suggestion that leads will be followed if people come forward voluntarily, through the slow accumulation of non-answers that add up to nothing being done. The Epstein scandal is not going away, and it is not going away because the questions at its center have never been properly answered, not by any administration, not by any DOJ, not by any FBI director who has sat in front of Congress and been asked directly whether they have read the victim testimony that names at least 20 powerful men. Subscribe, hit the like button, and tell me in the comments, after everything you just heard, do you think any of those names will ever be formally investigated? Because based on what happened in that room, I am not sure the people in charge want them to be. And that, more than anything else, is what makes this scandal so difficult to watch, because the system is not broken. It is working exactly as designed, just not for the people it was supposed to protect.